consumer protection in our office, and that's a really broad, it's not just mortgages, it's not just foreclosure, it's every kind of false advertising, every kind of deceptive trade practice that you can imagine our staff deal with. We're a small group, given the size of the state, the fact that we're now over 5 million in population. I really have 7 attorneys that work on all of these deceptive trade practices issues, in addition to work on mortgage and foreclosure related questions. What we do here though, and let me give you a 5-minute summary of the kind of things that we've been doing. In 2007, before the supposed crisis hit, we worked with about a dozen other state attorneys general and formed a foreclosure working group. And the goal of the working group was to start meeting with all the major mortgage servicers. And we sent out invitations to the top 20 largest mortgage servicers in the country. Initially, they were all willing to sit down and meet with us. And we had meetings in a variety of cities across the country with mortgage servicers, and started to talk with them and dialogue with them back in 2007 about the issue of loan modifications versus foreclosures, and trying to get some understanding or information from the industry about why they would process certain cases as foreclosures, why some as loan modifications, why loan modifications were taking forever, what percent of their defaulted loans were they doing loan modifications on, or other kinds of remedies short of actual foreclosures. And very shortly, it was clear to us that there were basically 2 distinct groups of mortgage servicers that we were going to have to deal with. We were going to have to deal with the bank-owned servicers, which account for in excess of 65% of all of the foreclosures in this country, and you're talking about Chase, Citi, Wells Fargo, and Bank of America. And they all have subsidiaries that work on servicing not only their own loans, the loans that Chase originates, or the loans that Citi or Wells or Bank of America originate, but they also purchase the servicing rights for loans that were originated by a whole variety of lenders. I mean, lenders that you would never have heard of, lots of lenders that no longer exist because they had their own financial problems. Washington Mutual, Wachovia, IndyMac, right? And the list goes on and on. There are literally hundreds and hundreds of lenders who originated your loans, who funded your loans originally, and turned around and sold them or held them until they basically went out of business, and then the Fed stepped in and found a major bank to come in and purchase those loans. We continued for the last 3 years. We have worked with the non-bank servicers, whether it's GMAC, Ally, whether it's Litton or Saxon, or I mean, it's an alphabet soup of companies that all combined, all totaled, probably account for no more than about 20 to 25% of the marketplace. The major banks, at the direction or at the request of their federal regulator, the Office of the Comptroller of Currency, declined to participate and to work with us. And what we've done over the last 3 years is we've published quarterly reports. Every quarter, the non-bank servicers send us all their statistics. And they explain, these are the number of loans in default, 30, 60, 90 days. Here are the number of those delinquent or default loans that we've done loan modifications. Here's what our loan modifications look like. And it's no surprise to anybody in this room, the results that we got back were pathetic. I mean, I don't know a better word for it. That they were doing loan modifications of less than 20% of their portfolios that were in default. And more, and this was before the feds stepped in and realized that there was a big problem. That the state attorneys general were trying to raise this cry since 2007, that what is happening right now was going to continue to happen, and it was going to get worse and worse. Finally, in 2009, the feds decided that they were going to require that their regulated banks, the big 4 that I mentioned,
Can I get a cookie?
that they were going to require them to start reporting monthly statistics on the number of loans that they had in default and the number of loan modifications they were doing versus the number of foreclosures. And if I said that the non-banks' results were pitiful, then I don't even have an adjective to describe how bad the record was of the major banks in 2009. And you know the story. I mean, since then, the feds have rolled out loan modification program after loan modification program. We've seen, HOPE, we've seen HAMP, we've seen HAMP 2, we've seen HAMP 3. And still, for the most part, loan modifications are either not happening or they're taking months and months and months, as your experience leads us to understand, to be finalized. We see people who come to the table, come to their lenders, and they have somebody who's willing to purchase their house on a short sale, right? If the bank will agree to accept a 10, 20, 30% off of the amount of that note, they've got somebody who's willing to come in right now and buy that house on a short sale, and they can't get approval. Right? They can't get approval. And the bank says, well, the investor has to approve it, the mortgage insurance company has to approve it, somebody has to approve it. So that was most of what we were doing up until 2009, was trying to work with the servicers to get them to start modifying more loans, to get them to dedicate the resources to do short sales more quickly. And because you're all here today, that was an effort that wasn't very successful. I mean, they didn't staff up, they didn't have the resources. It was way more expensive for them to go through all of that loan modification than to simply take that house in foreclosure as quick as they could. And so it's been an uphill battle. At the same time, we also are responsible for enforcing our state statutes that deal with foreclosure recovery or foreclosure repair schemes. And this is something, Ms. Cassandra, that I know that you're familiar with, where somebody will come in and they'll knock on your door or they'll call you up or they'll send you an email and they're going to save your house from foreclosure. And they got a whole bunch of ways they're going to do it. You pay them a couple of $1,000s up front and they're going to negotiate with your lender. They're going to get a quitclaim deed to your house and they're going to own your property and you're going to lease it from them and build up your credit. And when your credit's good enough, they're going to sell your house back to you at a premium. But at least you didn't go through foreclosure. And they don't pay off your mortgage even though you were making the payments to them. The house goes into foreclosure, and the guy who took your monthly mortgage payments for the last 10 months is gone. And we have these companies all over the state. Some of them are located here, some of them are based here, some of them are based in every city in the country, although disproportionately in California. And we have consumers that are getting bombarded with emails and phone calls about these loan modification schemes. We passed a law, we actually wrote a law and passed a law in 2006 that made it illegal for these loan modification companies to take a single dime of your money up front before they delivered on their promises of a loan modification or some other workout. We passed a law that says it's illegal for these companies who are trying to work supposedly on getting you out of foreclosure to take a quitclaim deed or any other interest in your property. It's illegal in Colorado. And we amended that statute on 2 different occasions to close up some loopholes. So we've been doing dozens and dozens of these guys. I need 20 more bodies just to deal with those cases. More recently, and what's been in the newspaper, and what I can talk a little bit about, but not in very much detail, is in October of this last year, of 2010, a lot of pretty much the same 10, 11 states that started back in 2007 working on loan modifications with servicers put together a formal investigation. And we said, this isn't working, right? We're getting more complaints than before. Foreclosures are on the rise. I think in Colorado, we're well over 40,000 foreclosures that were started in 2010. Now, only a fraction of those actually ever went to foreclosure sale, but still 40+ thousand foreclosures in Colorado, and we're not even close to the hardest hit state in the country, not even close. So we got together with a group of states and we started a formal investigation of all of the servicers, but in particular focusing on the major bank-owned servicers. Now, this is a complex thing because the federal regulators don't like the states playing around with their banks. Okay? They've even sued states' attorneys general before who had the audacity to go after a national bank. But since October, we have been in almost round-the-clock meetings with virtually every major servicer in the country. We're constantly in meetings and communications now with all of the players at the federal level, Department of Justice, Federal Trade Commission, Department of Treasury, Federal Reserve, FDIC, HUD, all of these federal players, the new Consumer Financial Protection Bureau, which was just created this past year, all working to try to figure out how do we not only fix the problem today, to try to provide some relief for homeowners, to get those who are entitled to loan modifications, to get them into loan modifications, but also to fix the problems going forward. Because, you know, we could put a Band-Aid on it today and we could fix today's homeowners' problems, but if we don't change the way that loans are serviced in this country, then we're going to see a repeat of this exact same problem 5 years from now or 10 years from now, the next time we have a downturn in the economy and we see unemployment rise and we see foreclosures rise. So that's what we're doing right now. I have myself and 2 other people on my staff who are working almost full-time just on this national project to try to work it out. I can't even begin to tell you where that's going to end up. It's just way too early in the process. It's way too early, and I've been in the Attorney General's office for 23 years, and this may be the most complex industry that we've ever really tried to look in and understand to figure out why it's broken and how do we fix it. So that's my quick run-through of kind of what our office is doing, and I really am more interested in listening to all of you and hearing what you have to say. We get dozens of complaints. We have a staff person that works full-time. It's a contract employee. It's very hard to hire new bodies in the state. We have a person who works full-time just helping us escalate mortgage complaints directly to the lenders, and we've developed contacts within each of the major servicers who we can call up, and it's not, you know, somebody with sitting in a cubicle and they just hired from Domino's the day before. These are, you know, vice president and higher representatives of these servicers, and we are having some success. But I mean, we've got one body doing it, one helping us try to escalate these complaints. Let me know. I'm anxious to hear your stories. I'm anxious to hear your questions, and I'll do my very best to see if I can give you some answers. I'm predicting that you're not going to walk away that satisfied because I don't have solutions, but I can let you know that this Attorney General anyway is committing a disproportionate number of his resources to this issue to see if we can't come up with something that works.
Sure. Hi, my name is Sharon McKee. My husband and Rick and myself are in foreclosure, and our sale date, which has just recently been set, is April 28th. Before the housing market crashed, we were middle-class Americans just like everyone else. My husband was a realtor, and I was staying at home taking care of my terminally ill mother, so I wasn't working at all. Our first modification was dated October 2009. Since then, we've had 2 other modifications. They'll give you the modification, but when they take it away, nobody seems to know why it's going away, but not to worry, you can reapply. It's funny to me how they'll accept the payments all along, but then all of a sudden they just want to slam the door. We have discovered that all of those payments, of course, do anything but go to late fees and penalties. That's all that happens to any of them. We have copied and recopied hundreds of documents. We receive phone call after phone call from Chase probably 4 times a week. They don't look at the notes to see that we just talked to someone 2 days ago. They just want to make sure that we know that we're in default, and if we just bring our note current, everything would be great. This is brain death. Why wouldn't I bring it forward if I could? According to Chase, our last foreclosure was canceled because they discovered that there was one document, it's the 4506, which is, you can look at my tax, okay? And I forgot to mark that we file at 1040. So the girl said, not a problem. Mark the box, refax it to us. So I did. But I didn't redate it and I didn't re-sign it. It was due in their office November 1st, and I have the document that says they got it November 1st. On November 3rd, they sent us to the foreclosure department. Every other document in the package had the same date, but that wasn't good enough. That day, you know, talk about heart-stopping type things. I spent 4.5 hours on the phone and I talked to 6 different people. Then I was transferred to Ida, and I love Ida. Ida's the lady who told me that not only was I in the foreclosure department, but my sale date was January 3rd. I'm going, no, that can't happen. Well, of course it can. I'm Ida, and I just told you it can happen. And by the way, you can't do anything about it, nor can you stop it. I learned that right then, that Chase can do whatever they want. I'm one person in a big pool. They can do whatever they want. They can take my home, not my house, my home. Rick and I are both, first, let me back up a step. I cry a lot, okay? I have this ugly little thing that when your hair turns white and you're a woman, it's called Sum's disease. And it's sudden ugly mood swings. And I'm having a mood chase, okay? So that happens to me a lot. My husband and I are both employed now. We have relatively good jobs. Rick has a good job. But now Chase has allowed us to reapply. Now they're not going to take the date away. They're not going to suspend that date. But each time I call, they have more questions. You cut the date off the top of the program. One of the papers was folded over. Constantly all kinds of things. I talked to Mark. He's the most recent person I talked to. And Mark told me that there's a 4-page application that's got all our Social Security and everything like that on it. So there's this 4-page application, page 1, 2, 3, 4. Well, 3 is folded over, so send it again, so we do. But you can't do that because they won't put it into the system because they didn't get page 1, 2, 3, and 4. They can't just take the old 3 out and put the new 3 in. So that's why they keep calling me and telling me that things aren't, or I keep calling them and they say that things aren't quite right. My husband is 62, I'm 60, everything's gone. Savings, 401k, everything to keep this house. Rick lost his business. We'll be filing bankruptcy. And I have to tell you, I believe it can be fixed, but my husband doesn't. We're going down a garden path, and they're going to slam that door one of these days, and they will get you out of your house. They will get you out. In the last couple of days, I talked to him a couple of times, so I just kind of did a timeline here of what happened. I called Chase, and Joanne said, everything's okay. George Mancini is my new manager, and here's his phone number, and don't worry, he'll be calling you. So on January 11th, I called back and said, gee, you know, I still haven't heard from anybody, and they said, not to worry, we're going to send him another message. On January 25th, they said they got all the documents, but some of them just weren't clear and right, so go back to the branch and refax everything that you've already faxed. Okay, I'll do that. On February 7th, all documents, another person, okay, they had opened the account for an escrow analysis, but they were not ready for review yet. On February 15th, all documents were okay, but on February 21st, oops, we have another little problem because they're really not all okay. So now I've faxed the new things on that, and now what they want is for us to update paychecks and our bank statement. That's okay. I understand. They want to make sure we still are working, that we just didn't, that we didn't quit our jobs after, I guess, we sent the first step. And Mark was just a wealth of information and a very nice guy, I guess. But, oh, by the way, the reason that we were in central foreclosure was really not because of the document. It's because the government, the feds, did not approve the parameters they were using when we gave them all our information about how much we're making and how much we spend. That whole program, that whole computer program, they didn't want them to use it anymore. So they threw that program out, and now they're using a new program. The only problem with that is there's all those people out there who were in the old program. So what they did at Chase is, anyone who had a modification, was 120 days or more old, automatically sent to foreclosure. We weren't just allowed to, go on with everybody else. Chase says it's the government's problem, it's not their problem. One of the things that you talked about, and I would like to mention, is short sale. Short sale has a lot of ramifications after you do a short sale. Tax ramifications and everything else. Sir, I don't want a short sale.
Right.
I want somebody to talk to me.
Right.
I want what Mr. Obama, they said because my document was wrong and they hadn't received it by November 1st, that I had to get thrown out of the Making Home Affordable program because I hadn't lived up to it. But I have a fax that says I was there by November 1st. I want I'm at 6.87% on my loan rate. I want a better rate. Go back and look at us for the last 25 years. We did fine until all these other things, until the economy crashed. I want a longer term. I want some time to breathe and put some money in the bank so that we can make those. I want all the things that Mr. Obama, God love him, said that we could get. But the trickle-down method isn't working real good for me. I prefer trickle-up.
Now, can I ask you, the loan modifications that you've done, have any of them involved the requirement that you make 3 or more months trial payments?
Those are all, yes, all of our modifications were trial payments.
And were they Chase's own loan modification program? Were they HAMP?
Well, no, they were all Chase.
Okay.
They were all Chase. Chase tells me that, because I was a Walmart customer, Chase tells me they took over the loan, our loan had been packaged and sold off to someone else, and when they wanted to do the modification, the investor will not agree to any of those terms. I didn't know the investor had to agree to any of those terms. Chase took TARP money. Chase took TARP money. My husband in the background. Yes, dear?
Excuse me. It's been way too long, so. The first program we did was the President's Program.
Okay.
We got a letter on a Friday that said, gee, we're sorry, but you don't qualify. The very next day, with no communication with anyone, we got a FedEx package with a loan modification application for one of Chase's programs. So, and I think now we're going on our 4th modification program. And what's disturbing to me, and I'm sure everybody in this room probably, but while you're going through this, I mean, you're in limbo. You can't, you don't know what's gonna happen, you don't know, but, so
That's
you're just kinda hanging out.
the most common complaint we get is just that people do not know. They don't know that the foreclosure hasn't been withdrawn.
Sure.
They don't know, they may have continued the one sale date you knew about, but unless you come back to the public trustee every week to check their sales schedule, you don't know when your house is gonna go to sale,
Yes.
right? And the only thing you know is that they have to go to sale within 365 days of the original sale date, or they have to withdraw the foreclosure and start all over again. But people don't know that. People don't understand that. People don't know that if it's going to sale 7 months after your original sale date, you still have a right to cure that foreclosure up till noon of the day before it goes to sale. But nobody sends you a notice that tells you that.
Well, I know, but what people sitting, and I'm gonna stop because there's other
Right.
people that need to talk, but who in this room can cure that? My husband's a vet, he's never used his VA loan. Why doesn't somebody talk to us about doing that?
Yeah.
There's lots of different things. They aren't interested. They want my house. They want my home. Bottom line, they would more than love Chase, Bank of America, all of them. Having been a banker for 28 years, they want in the real estate business. There's money to be made. And that's what it comes down to for me. Okay.
And with 18.5 million empty homes in the United States, it doesn't really make a lot of sense. It does.
I couldn't agree with you more. And they complain constantly about how much money they lose having to carry all these empty houses on their books.
Right, and how many times did they get paid by the government,
I know.
AIG, and all the others that basically got hosed in the process?
That's one of the things that we're taking a really hard look at.
So I'm gonna go on to Shelley.
Yeah.
Okay, thank you.
Shelley's next, because she's the.
Thank
I had a notebook like her notebook.
Oh, this is the Bible.
My notebook busted open and I had to buy a 5-inch binder for my documentation with Bank of America. I tried to get a modification of a HELOC in 2008, and of course they said, we're not gonna talk to you unless you're late, unless you default, so fine, I did. They said that they would lower our payments, I said, okay, this is what I want, they sent me paperwork, and I called the guy, I said, well, this doesn't tell me what my new payment's going to be. And he said, oh, we cannot tell you that until the next statement is generated, because it was a HELOC and something was different about that than a regular conventional loan, I guess. He said, but if you don't sign this, we can't help you. So against my better judgment, I signed it, I sent it back January of 2009, my next statement comes, and it's no different. But I was required to pay that for 12 months, because then I would be in breach of the modification that they had done.
And was this, I don't mean to interrupt, because I know this is
Okay.
going too late, but were the payments you're making more or less than your scheduled payment on your HELOC?
They were the same.
Okay,
They were the same, because it had gone from the interest only to the repayment
that's what I was
phase.
just gonna wonder.
Yep,
Okay, okay.
so it did not change at all. It rolled all of the late payments and everything to the end, and it did nothing to lower our payments. Of course, I wrote to the OCC, and that was back in, January of 2009, and there's still an open case, and they're not doing anything.
Okay,
So, more recently, my husband and I owned a small flooring business, and despite our best efforts to stay afloat, we had to close it in May of 2010. When our business began to struggle, we fell behind on our first mortgage as well, as we had been making the payments on the HELOC for a year. And we've been trying to obtain a loan modification with Bank of America since July of 2009, at which time they placed us in the Home Saver Forbearance Program. Our payments were cut in half for a 6-month trial. We had a contract that stated that Bank of America would suspend all foreclosure activity while we were in the program, and they would consider a permanent modification after the successful trial modification. So we made all the expected payments despite Bank of America's best efforts to sabotage it, because they kept returning our payments to us. They returned October's, they took July, August, September, returned October's, then they finally accepted it, returned 2 in November, and when I finally got someone on the phone, they said that they were gonna charge me to do a check by phone, because this was the 3rd payment that I was making to them. And so finally, her computer wouldn't work. I mailed the 3rd check, they accepted it. They accepted December's, and they accepted January's of 2010. So we successfully completed the trial modification in January of 2010. All the while, Bank of America had set a foreclosure date of February 17th of 2010, which continued to move forward despite the Home Saver Forbearance contract stating that they would suspend the foreclosure activity. We went to court in late December hoping to explain to the judge that Bank of America was in breach of the Home Saver Forbearance Agreement, but we weren't allowed to speak at all, other than to say we understood what was happening and that we were not in the military.
right.
We had a lawyer acquaintance who offered to file a petition with the court on our behalf to halt the proceeding based on the breach of contract by Bank of America for a reduced fee. After the paperwork was filed, the foreclosure came to a screeching halt. Had we not had that resource available, Bank of America would have foreclosed on us despite,
So you had to file a separate case?
Yep. right.
Okay.
So they would have foreclosed on us, and, you know, I just wanna know, how is the little guy supposed to protect his rights against these corporate giants when they can apparently do whatever they want, despite any, and I'm over the tears, you know, I cried for a year, I stressed out, I mean, I almost have had a nervous breakdown dealing with it. It is almost a full-time job dealing with Bank of America. We have sent Bank of America our documents every couple months, jumped through all their hoops, done what we're supposed to do, and this has been very stressful for our family, and we just wanna have this resolved so that we can get on with our lives one way or another. If this weren't such a serious matter, I would think it was a joke, as the incompetence that we have encountered at Bank of America, as high up as the president's office, has been absolutely unbelievable. And I, again, have a 5-inch binder detailing all of those efforts, and I'm happy to provide that. Thank you so much for coming tonight. I really appreciate being heard.
Does Bank of America have the first on your house as well?
Yep.
Were they did they originate these loans, or were they
Countrywide.
countrywide?
See, that's a big question, how's that gonna get handled?
I wonder if they even know who's, if they don't know where to even start, was my question. My question was, do they even know who their investors are? Because that's what they kept saying, is they need to talk to their investor about
Well,
modifying our loan.
A lot of times, depending on, sometimes investor means Freddie Mac or Fannie Mae. They own 65% of all the mortgages in the country. So a lot of times when your lenders are saying investor, that's who they're talking about. They're talking about Freddie Mac or Fannie Mae, and the Freddie Mac and Fannie Mae guideline. Do you understand who they are? Do you guys kind of have a sense for that? Because they're kind of a government supported, they're not really government agencies anymore, although they're being run right now by the federal government. They do have all these guidelines and all these, all this, this is what your income has to be, this is what your loan to value has to be, this is what your debt to income has to be, this is what the value of your house has to, they have all these guidelines. Freddie Mac and Fannie Mae tell us that they are not holding these things up.
That's who Bank of America is telling us is
Yeah.
holding it up, is
Right.
Fannie Mae right now.
Right, that's what,
Pass the mic.
right, anyway, I'm sorry, you
have a
have,
lot of questions from the
Oh,
audience,
right.
but we're gonna hold,
Oh,
so
okay.
we wanna,
Just two more.
speed, two more?
Two more stories.
And then we're gonna get
We're gonna
into,
Jennifer and
questions. I know there's a lot of questions in
Okay.
the audience.
Well, I just got information I wanna give people, I
Yeah.
don't wanna give anything
Okay.
else. It's.
Oh, I'm
it'll
sorry.
help.
We have some time for the dialogue.
go ahead,
Okay.
say that again.
Jennifer?
Oh,
Okay, thank you for your time, first of all. My situation's a little different, I'm not in foreclosure. On April 30th, I went to make a payment, an online payment for Bank of America, and my loan was getting ready to reset, the terms of it. On their homepage, there was a big advertisement, if your loan's getting ready to reset, you don't think you'll be able to make your payments, your interest rate's going up, apply for the Making Home Affordable program. So on April 30th, 2010, I applied for that program through Bank of America. I turned in my application, all the required documentation, and for several months after I turned it in, they kept requesting the same paperwork over and over and over. I contacted the OCC because they kept telling me I needed current paperwork. Well, when I applied, it was current, and Bank of America employee told me, well, we're really behind, and so we're not getting to the paperwork on time, so you need to provide us with new information. So I contacted the OCC in regards to that situation with the documentation. Bank of America got the correspondence from the OCC, and I got a letter on December 7th from a man named Carlos Escobar. He works for the president and CEO's office at Bank of America. What they did is they assigned me a workout negotiator. Her name is Candy Kim. Candy called me 2 to 3 times a month to give me updates on the loan processing, but all she ever told me was she hadn't heard anything. And since the process began, they made it so I can't make my payments through customer service or online. I have to call Candy Kim. Candy Kim can't take the payments, so she has to transfer me to somebody else. Every month for 10 months, I've had to go through this process just to make a loan payment. I'm totally current on my payments. On February 18th at 6:30 at night, I got a call from Candy telling me I didn't meet the qualifications for the loan, so they were denying it. I asked her what the qualifications that I didn't meet were. She said I had to have a current death in the family, divorce, or disability. I asked her if those qualifications existed when I applied for the loan 10 months ago. She told me she didn't know. I've done research on the Making Home Affordable program. Those aren't qualifications for that program. So they're saying I don't qualify based on requirements that don't exist. Candy told me the only way I might be able to qualify and they might be able to help me is if I was 60 days or more past due on my mortgage. She encouraged me to stop making the
60
payments.
days or 6 months?
60 days.
Oh, 60 days.
60 days or more. She encouraged me to stop making my payments, and after 60 days, they may be able to help me. She wanted to put me on the forbearance program. I didn't do that for the story she just told. I'm not willing to stop making my mortgage payments. I haven't missed a loan payment in 10 years that I've owned the home, and I find it totally ridiculous and actually frightening that they're encouraging people to stop making their payments. There's got to be some kind of preventative program that offers assistance to people before they can't make their mortgage payment, so that people can be proactive. It ruins their credit, they could lose their home. Right now, and this is where mine varies a lot from anything I've heard, Bank of America tells me that my original 30-year mortgage no longer exists with them. When I call customer service, my loan number, they said, does not exist on the computer. When they bring up my mortgage by my name, they said they are not allowed to talk to me. I'm only allowed to talk to the president and CEO's office. They won't return my calls. They said that they put me on a 12-month program while we're waiting for the loan modification, which 12 months is up May 1st. So as far as I can tell, come May 1st, according to what they're telling me, I have no loan.
Maybe they'll mail you the deed.
I haven't signed anything. The only thing I signed was the original Making Homes Affordable loan application. They've mailed me nothing on terms. I've signed nothing for them. So right now, I can't make my mortgage payment because nobody will return my phone calls. Customer service says my loan doesn't exist. They said they're not allowed to talk to me. Nobody from the CEO or the president's office will call me. I've contacted congressmen, I have contacted senators. They say that they don't have to help me, that they can contact them on my behalf, but that doesn't mean they're gonna do anything. My situation, my house is not only a home for me and my 2 children, but it's my only source to make an income. I run an in-home child care from my home. I've ran it for 17 years. I run it 24 hours a day, 7 days a week to keep my home and to be able to support my children. I've spoken with other banks, mortgage brokers, lenders. My situation is I can't even refinance. I have good credit and I've always made my mortgage payments, but my problem is my business is incorporated. So all my expenses and income shows on my business and not on my personal. We can't get a personal loan based on business income, even if you own the business. So I originally did a stated income loan. And not for the reason that a lot of banks put people in those loans, which is a whole nother issue for the liar loans. I went in it because I had no choice. For 10 years I've been making my mortgage payment. So basically, as I can tell, May 1st, I don't know where I'm supposed to make my payments. I don't know who has my loan. I cannot get anybody to call me back from Bank of America, from any department of Bank of America. And I'm not sure how I'm even gonna make my March payment because nobody will call me back. I have the money to make it, I don't know how to make it. They will not put anything in writing. If you email them, they will call you. If you send them a letter, they will call you. They will put nothing in writing. They do not want to be accountable for what their employees tell you. So basically that's my situation. Like I said, it varies in a few ways. So I'm not really sure where to go right now from it.
Who was your original loan with?
Countrywide.
Okay.
Countrywide.
Mm-hmm.
And they keep coming up, don't they?
So, real quick, before we hear from Ms. Pearl, Mr. Zavislan, I know there's a lot of folks in the audience have indicated that they have questions, et cetera. I wanted to just ask if perhaps you have another 15 minutes after 7 o'clock, so that like I said, there's a lot of folks we want to be able to get to, and want to respect your time, but also want people to be able to ask questions.
Sure.
If that's okay.
Yep.
Really appreciate that. Thank you so much, Ms. Pearl.
Be patient with me, I'm kind of shy. My name is Pearl Henderson Mixon. I'm not in foreclosure yet. I've made more money than I've been owed since I've been an adult. This is my second home. I was laid off 2005. I'm a single parent. When I lost my income, I had savings, and I took care of my mortgage. I was hired, I was laid off for 7 months. I was hired at the airport, and I was laid off 2 more times from the airport. With all the stress, I had a boil on my leg, had it lanced, and it turned into a MRSA staph infection. So I was out of commission for 3 months, and that was the mortgage. Wachovia Mortgage said you didn't make your payment for 3 months. They didn't put me in foreclosure, but at the time, since I was struggling with my mortgage, I went to Aurora Community Development Program, and they helped me navigate through Wachovia to get a modification. Before then, it was a year before I could get a modification. They kept sending paperwork back, same stories as these ladies. Before my modification ends, I'm trying to navigate to get myself in a situation for me and my son to stay in my home. I'm making the payments that they're required of me, interest only. But I don't know where I'm gonna end up at this point.
And have you started that process with them? Have you started to talk?
I started to talk, and, matter of fact, I have an appointment to kind of settle some things to see what I need to do to continue where I'm at.
My situation is different from everybody else's, but myself and my daughter wrote a letter to your office. I hand delivered it. You all sent me a letter saying that you all could not help me and help us, and that you at that time, that we had to seek help elsewhere.
Okay, I'll look at that, because I don't know, I mean, it would not have come to me personally, but.
Yeah,
I'll find out.
I walked both of the letters.
When was
in.
this?
This was back in, September of 2010.
Okay.
Yeah, so.
So real quick, I want to take a few minutes to talk, just very quickly, to talk about what we've been thinking about after, working with dozens of other homeowners around the state and hearing these stories so far. The Colorado Progressive Coalition has, 18,000 members in the state of Colorado. We have staffed offices in Greeley, here in Denver, and in Pueblo. But we're also a part of a national coalition of organizations, the National People's Action, PICO, National, the IAF Southeast, and the Service Employees International Union, and the Alliance for a Just Society. Together with our groups here in Colorado and around the country, we're currently representing hundreds of thousands of homeowners, and we had the chance in December to meet with Attorney General Miller in Iowa, and had a chance to lay out what we think belongs in a strong settlement with the banks that holds these servicers accountable, and I think gets to the fixes that we actually need. And so, very quickly, I want to represent just to you what we think are the tenets of a strong settlement and what we think would work to hold banks accountable. And then from there, I think that's the appropriate time to open it up, take questions, have people add on to that, etc. So first of all, what we need to see in any settlement, number one, is that there are real, meaningful, and permanent loan modifications, and that they're mandatory. And that servicers and lenders cannot initiate any foreclosure proceedings until all loss mitigation efforts have been exhausted. We don't believe that there's such thing as real, meaningful, and permanent loan modifications without using principal balance reduction as a first-line loan modification tool. So 100% to net present value of the home for all owner-occupied properties. Principal balance reduction to current market value has to be the first thing that a lender or servicer looks at when modifying a loan. Thirdly, there's a lot of folks, Ms. Cassandra and others who, because of the fraudulent practices, because servicers for years haven't gotten their stuff together, there's been millions of homeowners that have lost their homes through no fault of their own and illegally. So when in most settlements we talk about a dollar amount, we think that should be a restitution fund for borrowers that have already been harmed financially. And then fourthly and finally, and you alluded to this earlier, if we don't get in this settlement things that stop this crisis from happening again, that's not a good settlement. And we think a core component of making sure that this never happens again is that there are civil and criminal penalties for people that broke the law. And we're not just talking about foreclosure rescue scams, we're talking about CEOs of banks who have systematically broken the law and harmed homeowners in our communities. We have very, very high expectations for what a strong settlement looks like, and want to thank you first for all the work that you've done so far, but really need you to know that we think we need bold leadership from the attorneys general right now. We have lost most opportunities at our disposal to fix this crisis once and for all. Failure to pass bankruptcy reform in 2008, The fact that HAMP has no enforcement mechanisms, and it's voluntary, the bailout, we could have mandated all of this stuff when we were handing banks taxpayer money. We didn't. We've been failed over and over again by regulatory agencies, by lax laws, deregulation. We think that this investigation and a resulting settlement is our last and best, one of our last and best hopes for systemic change that gets to keep families in their home and fixes this crisis. And so, we'd like to hear from you if your vision for what a strong settlement looks like lines up with what we're thinking currently, and if that's something that the Colorado Attorney General's office will advocate for on the national team of attorneys general.
Well, it's a great question, and let me try to answer it this way, because we have, as you can well imagine, we've got, and I think I've seen a letter, not from your coalition, but from sort of a large group that represents a whole bunch of coalitions with that. We've received, we've received, and I've seen that correspondence. We've received, I can't even tell you how many dozens of similar thoughts, ideas, proposals from other consumer advocacy groups, from academic scholars who've studied this mortgage marketplace, and they think they've got solution X, Y, and Z to make it work. There's a group called Center for Responsible Lending out in North Carolina that's been really a strong advocate in this, and they've put together a very comprehensive term sheet that we've taken a look at. The bottom line is all of these things go into the mix. I mean, one of the things that we've done in looking at consumer complaints, in meeting with consumers across Colorado, meeting with advocacy groups, is we have literally started with every issue that gets raised, right? From the having to resend documents over and over again to, why aren't my partial payments being applied to my principal balance? Why are they sitting in what they call a suspense account that they tap into so that they can pay their late fees, and they can pay the housing inspector that drives by your house, or pay the realtor who goes by to give them a drive-by appraisal on that property. We've looked at forced placed insurance, where people, because they're delinquent on their loan, they let their property casualty insurance lapse, and so that they'll come in and they'll put a $10,000 premium on your house for 1 year worth of mortgage insurance. We've looked at, how forbearances are handled, how foreclosures are handled, how loan modifications are handled, both from having a single point of contact so that you don't get bounced around from person to person, names and faces change all the time, to some seamless way for you to get your information to them so you don't have to fax them from their branch, so that you can make your payments and you know that your payments are being made and they're being applied correctly. The list is, if I had to put it in outline form, it'd probably be 40 pages long right now, because there are so many issues. Our goal going into negotiations is to try to get everything on that list. And we're trying right now our very best to work with the enforcement agencies of the federal government, because there are, like it or not, there are these major bank players who are their responsibility. The Obama administration created something called the the Financial Crisis Inquiry Commission.
FCIC.
Right. Attorney General Suthers testified before that commission about this time a year ago with the Attorney General from the state of Illinois. And in December, I think they came out with their final report. It's massive. It's hundreds and hundreds of pages long. But a lot of the blame for what happened, they laid right at the doorstep of the federal regulators who were supposed to be out there watching for our rights. Well, we're now trying to work with those guys. But I can tell you that if that isn't feasible, we're not going to hesitate for a second to say, the heck with you, and we're going to go do our own deal. But I think the best long-term solution is going to require that we get these federal regulators on board, and to get them to stop pandering to the banks and the clients that they supposed to regulate, but who pay 100% of their operating budgets through their membership or through their regulatory fees. So I don't think that there's anything on this list that's off the table. I think all of these things are being discussed and many more. Where the devil is in the details. Principal balance reductions for which homeowners? I mean, that's gonna be a critical issue. Right now, more than 40% of homeowners that are facing foreclosure never respond to their lenders' letters, phone calls, telephone call, or emails, right? They pack up and they leave. I mean, it is really, that was one of the most most surprising facts that I learned about through this process. Over 40% of homeowners who know they're losing their house don't ever contact a housing counselor, which I encourage everybody to do. Don't ever contact an attorney, but most importantly, never respond to their bank when their bank's saying you're 90 days late, what do we want to do here? They throw up their hands and they go into a shell and they never respond. So I don't know. I mean, we're trying to figure out what do we do with those homeowners? How do we make this, how do we make it more likely that they're going to engage with their lenders and try to work something out, assuming that we can fix the working something out part of all of this. So it's incredibly complex, but I think everything on this list is still in play. I mean, it's part of everybody's agenda to try to make this work. And so I don't know how you want to do the questions, but.
So, thank you, and I think, how many questions we have? 1, 2, 3, 4, 5, 4. Okay, let's just start from the back and move our way forward. Does that sound?
I know, that is.
Vicki,
Chris.
Chris, sir, did you have your hand up?
I get where your point is.
Gordon, can we do that order right there? Let's kind of work our way up. Thanks.
First of all, our mortgage company has no idea what our principal balance is. And we've made thousands of dollars worth of payments that were never credited. So to come to some kind of discussion with them about a reduction when we can't even have a discussion with any human being about what the balance is. And there's no way to get an audit because when you ask for the requirements under RESPA, they just send you this, if they send anything, most of the time they ignore it, but sometimes they send you this big giant mass of paperwork that it proves that they didn't apply payments. But where do you go when you get that paperwork? There's no, what's the recourse to say, okay, we know that you violated RESPA, we know you violated the Fair Credit Reporting Act, and we know you're in breach of contract. What do we do?
Right, she's referring to what's called a qualified written request under RESPA. Technically, it exists for that very purpose. It's for you to get the accounting on, in theory, you should send a qualified written request and you should get back a statement that shows payments made and payments applied. But what's happening out there is people are, if their payment is late or it's short because that was a bad month and so they sent a partial payment, they're not applying that payment to your loan balance. They're putting it into what's called a suspense account. And that payment then sits in a suspense account and it just starts accumulating. Because then your next payment comes in and it may be complete for that month. Say you made a partial payment in July. You make a full payment in August, but you didn't make enough in payment in August to make up for the shortfall in July. So they don't look at that August payment as a full payment. They look at that as another partial payment because they'll apply it first to your past due balance plus late fees plus everything else. Now that payment's incomplete. So that stays in suspense. And you literally, as a homeowner, find yourself in I can never get caught up unless somebody gives me a check for $5,000 that I can walk out and do
When
it.
they started putting us in suspense, we were never behind. I sent them bank
Right.
records, I sent them
I know.
everything. We had never made a short payment.
Right, and this is a major issue
Then
that
whenever
we're
we
looking
got to
at.
the point of trying to fix anything, they transferred our mortgage to somebody else, and then somebody else said, start over. And pretty soon, there was points where there was nobody to make a payment to. I mean,
Right.
for 2 years, we had to beg people to take the payment.
Heard this
But
story.
the whole thing is that you have no recourse. There's nobody that you can go to say, okay, they violated all these laws. Because you can't do it at the Rule 120 hearing. They won't even let you talk.
Right. Right, I mean, the rule,
And there is no lawyers in Colorado that I know of that are suing people. I'm an attorney myself, and I've talked to real estate lawyers, I've talked to contract lawyers. I can't find anybody who knows how to do the whole area that this entails to sue them. And it seems like the only way that you can do that is to sue them. Well, most people that are in foreclosure, whether they got there because of mistakes by the bank or whether they got there by their own, the economy, they don't have money to hire a lawyer, but even if there was money to hire the lawyer isn't out there to hire.
one of the things that we're taking a look at, I mean, Rule 120 hearings because it's a rule, it's not a statute, so it's not something the legislature says. The Colorado Supreme Court sets our rules of civil procedure, and years ago, I mean, this very limited Rule 120 procedure goes back a number of years, and it hasn't been modified or updated to recognize the fact that consumers aren't getting a voice. And it wasn't designed to give you a voice. It was designed to give a judicial stamp of approval over your foreclosure and require that the bank establish that you're in default.
But that goes all the way back to 1874
Well,
from the silver bust.
Yeah, but that Rule 120 doesn't. But my point is, and I know it frustrates consumers like crazy, but the courts are not supposed, in a Rule 120 hearing, supposed to hear anything other than, are you current in your payments or are you subject to the Service Members Civil Relief Act? And so consumers get...
But if they're in breach of contract, then how can you be in default?
Right, because, and I bet you...
So your argument is you're not in default because they're in breach of contract, then they say you can't bring up that argument in court.
Right, you have
Which
to
is
file a
violation
separate
of due
case.
process.
I know.
And there is no due process in this. You get more rights going to small claims court than
Yes.
you get in the Rule 120.
Absolutely.
And the judge
I can at least
never
get an
asked for an
attorney if I go
IOU.
and rob somebody.
No, that's exactly right. I mean, it's exactly right. And we're in discussion, we've been having discussions with the public trustees who administer this. We've been having discussions with all the law firms that are foreclosing on everybody and are representing all these banks. We've been meeting with people trying to figure out, state legislators, trying to figure out how can we make that process more equitable. Because people they're in foreclosure, which means that they're not in great financial shape. They're not gonna go out and find and hire and pay a lawyer. Right now, the only way to do it is you gotta either pro se on your own or hire a lawyer and file a separate lawsuit. And
You
that's
gotta go federally, right?
Well, you don't have to go federal. You don't have to go federally, file it in your state court. It's cheaper in state court anyway.
And what if you hire an attorney who colludes, and then you represent yourself pro se, and they blatantly violate Rule 17 of evidence, steal your house with falsified information and know it's falsified?
Oh, yeah, REMIC and UCC claim your office has
So
it.
if we have limited time, and I think people had their hands raised, so let's get around Vicky, Chris, Gordon, and then did you have your hand, and Christie.
I got
So-
some information to help people.
Okay, well, a couple things. While you're sounding just as helpless as us, and that doesn't make me feel good. And so, I mean, with you agreeing and all that, with all due respect, you know, your office has, you guys are number one, you're the chief legal counsel for the government here, right? State government.
For the government.
Right, and the other thing that you also do, don't you have certain executive enforcement responsibilities?
I'm not sure I know what executive means, but we do enforce, there are specific law, I mean, our office we're not just this wild card cop that can go out and sue under any law.
I understand.
Legislature said, the Attorney General, you can enforce this law, this law, this law, this law.
Right, okay, but with that being said, you have some power.
Absolutely.
And so, okay, so we needed you guys, because you said y'all been chit-chatting. I'm done with the little chit-chat and do some law enforcement. And so until you can figure out the specifics, and you're trying to collaborate with the federal government, what you could be lobbying now, particularly since you guys are lawyers, is to put an injunction and a moratorium on this whole mess. So if it takes y'all 30 years to figure it out, at least there'll be a moratorium on these things. So that's something you can do right away. You can begin to move on that. That'll help you breathe. So we can be chilling in our houses while y'all figure out the mess. And I'm sure y'all will come up with something quick, fast, and in a hurry. But that's one thing you can do. Hopefully you can write that down. The other thing I want to say really quick, and I need some answers from, is that I have been involved in several pro se cases. All y'all judges know me. Your office knows me. The problem I have with it is the fact that you guys are the chief legal counsel for the very judges that sit back and allow these banks to do that. If there's a serial killer, at some point somebody's going to look at the policeman and say, what in the world are y'all doing? So I'm looking at you guys and saying, Mr. Law Enforcement, what in the world are you guys doing? And if we had the audacity, unmitigated gall to lead in foreclosures well before it became a national epidemic, why in the world would you lead? Why are you waiting for federal government and other people to come in and jump? Like the man said here, you guys need to show boldness. You need to say, just like the lady in Arizona who's trying to get rid of people, Governor, whatever her name is, and just like this knucklehead man now who's stealing rights in Wisconsin, we need you guys to get up and say whether the federal government does anything or not, we are going to protect our people, because if we can lead in the foreclosure epidemic well before it became national in the state of Colorado, surely we can lead in finding a resolution. So the moratorium and the injunction is something that you guys can do right away. And you guys need to be advising, since you're the chief legal counsel, you need to be advising your judges to quit colluding, because I have sued several of them, and your office represents them. And y'all met me in the federal court while I stood there by myself, and they made me look like a complete idiot with falsified documents, and I'm facing a federal criminal case right now, and the accusers that are coming against me are the very banks that I've decided to sue many years before this thing became popular. So I'm putting that at your feet. I've got letters with you guys. You just got another notice of claim where I'm getting ready to sue another judge, and that's what you guys can do right now. So I don't need, if I go to a counselor and a psychiatrist, I don't need her laying in the chair too. That's what you're doing. We've expressed ours. We need you to begin to do something, and that's something I believe, sir, without due respect, that you can do. Now, surely you understand my passion. If you were homeless like we are, and we're living in Crossroads, and they told us to go stay in a homeless shelter, and on August 24th, because I was holding these cases up in court, the police came to our house August 24th at 7 o'clock in the morning with the alarm company. They changed the locks on my house, made us stand on the sidewalk in our nightclothes with absolutely no court order, and I was able to record some of it. They did all these different things, and now I'm out of my house with absolutely no court order. Please, y'all need to get busy. And so this is the whole rules, and I would say to all y'all, your stories are the same. So at some point, you got to say to yourself, you got to quit saying the same stuff. We've been pumped enough with all that, and y'all got us on the rules. Hold and loss mitigation. Ooh, half a payment. And you just like, yeah, we talking. I don't want to hear that. Get busy.
Well, we have an opportunity right now. Right now, we are getting ready to vote for the mayor of the city and county again.
Yes.
They appoint the judges.
That's right, the corrupt judges.
Oh, and they're all corrupt.
Oh, I can.
And you guys
I
protect
know
those
that.
judges.
I've done this
They defend
19
them.
months.
It's their
Just
office.
to keep on track here, because we have limited amount of time, thank you so much, Vicki.
Okay, I'll hush.
Chris?
Couple issues,
Board.
what are all the state attorney general doing now with the entire securitization matter?
Yeah,
Can you please repeat the question?
Yeah, his question was, what are the state attorneys general doing with regard to the securitization mess? It is completely wrapped up in all of these discussions. We have met with some of the largest investors, the people who are buying those securities, who are losing their money as well, and I don't have much sympathy for them because they had millions and millions to invest in these deals. But it had the problem with the way that they pool 10,000 mortgages into this big security that they then sell all over the world is that it's complicated ownership of the notes and the deeds of trust.
So, having said that, okay, hold on. Countrywide originated, gee, how many of us have a countrywide origination? Within 3 weeks, was sold into a Fannie Mae security and took off from there. Where does that give Bank of America the right to foreclose?
Oh, that's a great question. That's a great question. The question is, if the loan is sold into a security, call it ABC Trust, what gives Bank of America the right to foreclose on your house? And it's actually an easier answer than I think you understand, and that is, in Colorado is the only state in the country that does foreclosures the way we do them. In Colorado, the owner of the note, the person who lent you the money, or the person who bought the note from the person who lent you the money, isn't the only one who's allowed to foreclose. In Colorado, the servicer, who just has a contract with them,
Not true,
has the right to foreclose in Colorado.
not true.
Well, ma'am,
Why?
I beg to differ.
Let's be respectful.
Why? Because the, an interesting point is, in one of the statutes, it says either, and one of your county trustees brought this up and said, this is a serious concern.
Right.
You're either a holder, or you are a qualified holder.
Yes.
And her attitude was, look, you're either one or you're the other. And I had in my case, when one document it says they were a qualified holder, and the other document, they said they're the holder.
Right. We've run into that issue. We're trying to figure out because, well, here's why. Here's why. Colorado law, foreclosure statute define a holder both as the owner of the note and anybody else entitled to enforce. That's what Title 38 says. Entitlement to enforce means you don't have to own it. You just have to have the authority. And you can get the authority to foreclose by contract as a servicer. And if you look at Freddie Mac or Fannie Mae standardized contracts and notes, they allow what's called a non-holder in possession, a servicer, to file a foreclosure. Now, what doesn't make sense is there's no consistency as in Colorado about how that's being done. So we see servicers who are being challenged in court, who are trying to show up and prove that they're the owner. But they've never been the owner.
Exactly.
They got hired by the trust to service these mortgages.
Well, in my case, it wasn't the trust. When Countrywide went belly up,
Right.
Bank of America, I never asked Bank of America to
Right,
come in.
Right, Bank of America acquired all of those Countrywide loans.
I didn't want them to touch my loan.
I know, but unfortunately, you don't have that control. They have the right. These are negotiable instruments, so they can sell them and buy and sell them. And so you see, Wachovia being sold, you see WAMU notes being sold, Countrywide ended up at Bank of America. It's endless.
Out of control.
It is completely out of control, and the marketplace grew up before it was mature enough to handle it. If you saw the number of mortgages that were outstanding in 2001 versus the number of mortgages that were outstanding in 2006, it would blow you away.
Okay, so having said that, let's go back to dirt law.
Right.
And say, well, what about all the assignments?
Right.
If this thing got sold through all these securities, and they really have paper, how come the assignments aren't there, and how come they're not required in Colorado
Right,
to show those?
Where's those accounting papers? They don't wanna show their,
Oh, they're
what they,
accounting.
well, yeah, there's some
Yeah,
accounting ledger.
that's a different issue than the assignment. You're absolutely
Well,
right, though. Assignments
they all
are
have
not
those
required
hand-
in Colorado. Right? The banks take a big risk by not recording assignments, because it means that somebody else can come in and record ahead of them of record against your property. And that's a problem for them, but that's their issue. They do not, the statute says that they just need to bring in a copy of the deed of trust, a copy of the note, and they have to agree, if they're foreclosing on photocopies, that they indemnify you from somebody else coming in with another copy of your note or the original of your note, so that you as the homeowner don't get sued twice on the same obligation.
So
That's
when Bank of
in theory
America
the way it's
foreclosed on me 30 days later, sold my deed to Fannie Mae
Right.
for $10,
Right, well, they assigned it to Fannie Mae. Fannie Mae was the owner all along.
then why didn't Fannie Mae foreclose?
I don't know
if
why,
they would've-
in some states Fannie Mae does it, but in Colorado, they do not. They foreclose through their services.
Well, then
Okay.
they're not really the holder. It
But
goes
they
back to the
don't, my
same
point is
thing.
they don't have to be the holder in Colorado law.
So Mr. Gordon had his hand raised. I'm sorry, Chris, I just want to
No
make sure that
problem,
everyone,
no problem.
while Mr. Zavislan committed to 15 more minutes, we have another 5, so Gordon, and then Christie. Sorry.
Right.
That's no
Okay.
problem.
And then that way, that's all the time we have with Mr. Zavislan. I think we want to spend probably 15 minutes kind of debriefing, thinking about next steps together. So let's go ahead and let's try to, if we can try to use the most of Mr. Zavislan's last 5 minutes here, Gordon, Christie. Okay? Thanks.
Yeah, I'm a retired trial lawyer. I don't, you know, I've chosen not to have an office and malpractice insurance and all of that. I was trying to help, I wanted to be able to help people that were victims of these foreclosures, and volunteered with legal services and found that people weren't qualifying for legal services that were losing their homes, so I couldn't really help them in that respect. You indicated that you only had one person answering the phones and taking complaints or something like that?
No, escalating. We have 3 people who do our complaint intake, but we had to bring on somebody who when we get complaints like yours, I mean, like where people are just having runarounds, and I've sent my paperwork in 1,000 times, and I think what this person does is they escalate specific complaints to the servicers, and we have contacts, we've developed contacts with these servicers to try to see if we can't get somebody who really knows what the heck's going on at those servicers to take a hard look at this loan. And we've had some real successes in doing that, but it's not anywhere near enough.
The question is, do you have some suggestions for people that are willing to serve as volunteer attorneys without, I mean, you know, where I would,
You know?
I'm not really, like I said, I'm not interested in a for-profit law firm.
Well, I mean, or
if there's some way I can help you at the Attorney General's office.
Right, I was just gonna say, I mean, we would love to have some volunteer experience. If you're willing to, you know, let me leave you with my card. Give me a call, and, you know, if we could get another body or 2 bodies doing this, looking at these loan files, escalating these complaints, you know, it's all the better. We're in the process right now of trying to do a 2-year grant to the Colorado Foreclosure Hotline to keep them up and running, to get them more housing counselors. They have a bill in the legislature this year to create a funding source to hire even more housing counselors in
I'd
more
like to be able to
neighborhoods.
consolidate the kind of complaints that you've been hearing today.
Yes.
I'd like to see the Attorney General office have more opportunities for hearings, because it seems like there are a lot of people who have complaints that don't really have time right now to have their complaints heard. And I think people want to be heard.
No question. I mean, this is really, and I know that there's a lot of emotion on this, and, you know, it's easy for me to sit here and say, I get it, I'm not going through a foreclosure, so maybe I don't get it. But you do, I mean, but I think we do try to listen, we do try to hear these, we do try to match this passion for change with achieving real and meaningful change, and I think that's what your coalition is looking to try to do. At the end of the day, I mean, we're not gonna be able to get everybody in America their house back who defaulted on their mortgage and lost their house to foreclosure. You know, I mean, it's because a lot of those, she asked why not, it's a legitimate question. Because a lot of those, I mean, I mean, there are a lot of borrowers who, through their own fault or no fault, health, employment, circumstances of life, couldn't make their mortgage payments any longer, and chose to walk away from their property or didn't qualify for a loan modification. Those houses have been sold, and maybe a new family has purchased that house and is making that their home. And so I don't know how you undo all of this. I mean, it's a legitimate concern, it's a legitimate question, but there's going to be limitations on what it is we're going to be able to accomplish. I mean, you're talking about, I don't know, what by now, 4, 6, 8 million homes nationwide.
Make them do their
18.5 million homes are currently sitting empty in the United States.
Yeah, sitting empty, and a lot of those are abandoned empty, not foreclosed and sold empty, but you're absolutely right.
Yeah, Bank of America forecloses on a whole bunch of houses in Chicago and then walks away from them.
You know, we've been meeting with a lot of the cities who are facing costs of trying to keep these properties safe. So anyway, I'm sorry. So anyway, so I'll let you have my card, and then let's see if you've got some time and the desire to come in and do some. I mean, we can't squeeze money out of the legislature to hire bodies. We just can't squeeze the money out of them.
I wish you had have mentioned that the Attorney General's office did prosecute Shapiro having litigated it,
Yes,
and he got a conviction.
yes.
And the individual that was involved in this was found guilty, and they're
Yes.
sentencing them on the 4th of March, and so
That's very interesting that I mean, I hope that you're aware of this because
I was involved in
I
the
was
suit.
afraid to ask if you
Yeah,
were.
I was involved in the suit. I
Right.
mean, I still got my house sold,
Okay.
and I have to send out a letter of intent.
Right.
And it took me a while,
Right, right, I know exactly which case you're referring to.
yeah, I'm sure you do,
Yes, I
because
do.
it was $75 million
Yeah.
on it, so I know.
Okay, ma'am, you had.
Is this a question or
I'm
information
gonna
sharing?
give some
'Cause if it's a
information.
question for Mr. Zavislan.
Well, there's gonna be a question at the end.
Okay,
I'm
so we've got
quick.
3 minutes, as long as it's 3 minutes,
I'm
that's cool.
quick,
Okay,
alright?
fair enough.
I'm Christy, I live in Elizabeth, alright? And I've been fighting this 19 months. They're past their time now to go ahead and foreclose on me. Although they're still trying to go ahead on the system of abandonment. The fact of the matter is here, they were always thinking I was agricultural. I'm only on 4 acres, and it's always been 10 years of residential, never taken out an ag loan. Never been insured agricultural. But they're still persisting it, and this is Castlemine Holden Stewarski's. Whoever has Castlemine
Yes,
Holden
please,
Stewarski.
I'm so in the middle.
Okay, I got a lot of information, but we won't go over it now. I had done some more research. I called out to Illinois, and I talked with the Secretary of State there. I hold in my hand a very good copy, which I paid for, Mortgage Electronic Registration System. They went ahead and they go ahead in here and they said, this is their stockholders report. And states and countries in which admitted to qualify or transact business. Now keep in mind again, this is 18 of 05, November 18th of 05. Alabama, Delaware, Mass, New Jersey, New York, Ohio, Virginia. Did anybody hear Colorado? Let me go further. I took out my loan in September 17th of 1999. I have mortgage electronic registration system on my deeds of trust. Okay, it is a trust when you go ahead and you put your IOU and your deed together. But when they take that IOU and they put it into the REMIC and they turn it into a stock, they have to by law destroy that IOU. What does your deed of trust then hold? What does it securitize? Nothing. All right, now, it's an unsecured debt. They got paid off on tax credits. They did that to avoid the tax credits. Not the REMIC or the servicer that's there can do anything but to collect the money. And at that point, if they sell it and they sell it and they sell it, and they did it up front, just like a paper you would write a check on, or you'd buy a Rembrandt. It's that purchase, that one only. It's not for them to come back with a copy and say, I got you. I got you, you know? And this is the thing, I had a First Magnus loan that Castlemine Holden Stewarski is holding hostage, saying, oh, well, we own this. Well, you know what? I have proof that Countrywide stopped conveying the notes in 05. I have proof for the fact that First Magnus has a lawsuit that said, stop doing business, cease and desist. And they sold everything to Sharper Lending. Oh, here's one better for you. They're still claiming, and the SEC says we have nothing on First Magnus, we have nothing with the SEC. FDIC sent 4 papers in, and Castlemine Hold was very nice. Oh, they put it in the judge. There's 4 pages. Each page has to be notarized, completely notarized. The second page out of the 4 pages was blank. It was still submitted in as evidence. It's an incomplete document. It's fraudulent signatures, all right? I have things that say County of what is it, Dubois or something like that in Florida. Well, Castlemine Holden Stewarski is part of the default law group in Florida. They're under falsifying documentation right now. All right, now granted, it has nothing with what they've done yet in Colorado, but I have taken my stuff and I've had audits, and you all need to get your audits done. Audits, all right? Loan Compliance Advisory Group, Joe Bazagno. He's had 30 years in the service of doing audits, 30. And he has taught judges across America. He has dealt with them, and that's how this has got changed. All right, he is dealing with Neil Gardner, all right, and this stuff here, this woman knows. I showed her some of my paperwork, okay? And he's a retired attorney, and respect you, thank you. Okay, the fact of the matter is that this stuff is getting done. I have Clouded Titles, Matt Krieger, $20, you can get it for 25. It's a hard copy. Read it front and back and read it again. It tells you exactly what's going on in the system, and he too is teaching judges, and he has shown people that there's clouded titles. When you have MERS in your paperwork, they cannot be a beneficiary on one line and an assignee on another. You can't do it. It's illegal. All right? And this is the stuff that I brought into the Attorney General's office, Annie Oakman Gardner, Senator Bennett. I've been doing this a year, and I'm telling them, it is not right for telling people to do a loan mod.
That's right.
Here's the evidence right here
That's right.
of one reason why,
Rules.
one reason why they give you the runaround, they do this
Yeah.
stuff, they give the money to the bankers, and then I went into my county, okay, on Monday, I wanted them to record some paperwork. Now, since I live in the backwoods, as everybody says, you're in Kansas, girl, okay, good. Well, let me tell you something, I have a house in Thornton. I wanna get with you, because the fact of this, Castlemine Holden Staworski says, they're a debt collector attempting to collect the debt. Well, no, well, hear me out. This is the real truth, okay? And I have clouded title, and this is gonna happen. But the fact of the matter is they're using my deeds of trust on Elizabeth to collect on my house in Thornton. I went up to Thornton, y'all get your copies of your deeds of trust, you get them certified, okay? It's a little bit more money, it's well worth it. And then from there, Adams County had changed one of my original documents and took off my pool and service agreements. I got that certified. The other thing is that they're using my deeds of trust on my Elizabeth house to collect on my house in Thornton. Whee! How can you do that? We as a debt collector attempting to collect the debt. All right, now, they don't even know that my house in Thornton is paid off because Jamie Dimon, after all my QWRs, finally caved and said on Christmas, around Christmas, I don't have the original contract. Thank you. Brian Monahan still told me my QWRs overly burdensome. You know, hey, we don't have to answer to your second. Well, let me tell you something. I did all my research, and I've been working with Loan Compliance Advisory Group. I've been working with Matt Weeder. I've been working with all of these people that are working in America to change everything. Okay? And I came here because Chris told me about this tonight. I'm gonna change this. And I called Annie and I said, I even went to 9 News when I woke up at 7:30 in the morning, and here's Senator Bennett when I gave him all this information for a whole flipping year. And I said, you either call me or I'm going to 9 News. You've got a choice. I've got the evidence. Here's one better. Castlemine Holden Staworski has Cooper Castle out in Nevada.
Christie?
It is all tied in back to Colorado.
Sorry, I didn't to interrupt, I just,
They're crooked.
we're gonna have some time for some conversation. I didn't quite hear a
Oh,
question there from
they're
Mr. Zavislan.
crooked.
So if we can go ahead, I think we're a little over time, but I feel like people that had hands up, we got at least to ask the questions we wanna ask, right? So,
The moratorium is the only one. You don't admit to doing a moratorium, because you can take as long as you need to figure out the problem. We good with that. But meanwhile, you can stop this stuff. Because I don't understand how you guys allowed them to, you let the banks do a moratorium when they felt like it. Did y'all notice that?
And why is Arizona?
But when we
everybody
tell
else
them, who we put in office to do a moratorium, you guys can't go for it. So I want you to say, before you leave here, I would like to know if you are going to put a freeze on that until you can figure out all this mess, or at least lobby for it, begin to do the legal work in order to see that that's brought to pass. We can wait till y'all figure this out, since you can't figure it out yet.
Right, I mean, we can certainly, here's the problem, I mean, it sounds great, it sounds like this is the easy solution, let's just stop them, but it's just doesn't work that way. I mean, you can't, there's no, the Attorney General can't make law, and there is no authority in the state of Colorado for the Attorney General to simply declare no more foreclosures until we get this.
Arizona did it, why is that?
You know, Arizona, no, that
respectful.
is not true. The Arizona, Jan Brewer made a big splash about how she was gonna ask the banks to do a moratorium.
I just had that. She did. It's done.
And, well, it's interesting, because I'm on the phone every day with Arizona, and
All
their
right, well, wait a
foreclosures are
minute,
way up.
I have it, and I brought it here.
But it's not worth having the argument. The issue is, can you ask, you can request the banks to do it, and we've done that. But I don't regulate Bank of America.
I want you
They're
to
a
sue
national
it.
bank.
I want you as the,
Okay.
I want you guys, to bring, I want you guys
This
to
isn't gonna
bring.
be a shouting match. I mean, I
Is
just.
this not, no, you asked if all our questions were answered. This is something that your office can do now. Just like Sharon Lewis, I heard on the news that you guys are suing him and you're asking the courts to place an injunction to stop him. But yet you're telling me that you can't document to at least ask that there be an injunction placed?
I'm not gonna discuss him because it's a pending litigation.
Well, I'm not asking, but I'm just juxtaposing the two, saying that don't come to me with this mess. I understand it's a process, but I'm asking you to start the process because you can at least freeze it and stop us from bleeding.
Right, I mean, I think it's.
So get to it.
And what do you
And
guys
don't keep
say
telling me
about
to be
murder? That's-
disrespectful, whoever
I'm
keeps
sorry,
saying that.
excuse me.